In today's video, we're answering the question as to whether or not you can talk to the prosecutor if you've been charged with a crime. People will call our office, they'll say, I'm facing criminal charges. I would like the opportunity just to explain to the prosecutor what happened. They want to tell their side of the story because that's their first instinct. Let's break it down just a little bit further so you understand how this dynamic works. So, if you're charged with a crime, and you do not have a lawyer, meaning you have not hired an attorney, or the crime is not requesting jail time, the prosecutor is not asking for jail time, and they're not going to give you a public defender, then you're on your own throughout this process, and you have no choice but to go talk to the prosecutor. During the pre-trial negotiations, you have to go talk to the prosecutor because they are representing the government. You are the defendant and you don't have an attorney to help you through the process. So you have to talk to the prosecutor if you are not represented by a lawyer. Now, if you're going through that process, if you're watching this video because you cannot afford an attorney or they're not going to appoint one for you in a lower level misdemeanor case, it's important to understand that the prosecutor represents the government. They do not represent you in any capacity at all. They're not there typically to facilitate a resolution. There are some prosecutors who are very good people and they're trying to give you, trying to reach a good outcome with you. That's typically smaller jurisdictions with single prosecutors. If you're talking about a bigger city like Scottsdale, Mesa, Phoenix, or any of the bigger cities around Arizona, it's much more of a systematized prosecutor's office, and they have policies that they need to follow, so they are not looking out for your interests. It's typically, in our experience, not good to discuss the facts with them. Meaning, if you go in and you talk to them and you say, this is what happened in my case, this is my side of the story, or any of those things, the prosecutor is now aware of your trial strategies or your position. They cannot use a lot of that against you because there's some certain rules in place about pre-trial negotiations and those things, but it still is providing the prosecutor with additional information that they otherwise wouldn't have, that we as defense lawyers wouldn't give them absent some certain scenarios or certain extenuating circumstances. So traditionally, it's not good to go in and tell the prosecutor more about what actually happened, because they, in most situations, they're already predetermined as to what they're going to offer you. They're going to give you a plea deal that was decided before they heard your side of the story because, like I said at the beginning, they are a bigger prosecuting agency, and so what they do is they have policies that they follow. So they'll say, if you've been charged with this crime, then based on our policy, this crime says this penalty, and they'll reduce it a little bit to give you an incentive to take the deal, but they will have that plea deal prepared before you even go into court. So if you think that you're going to talk your way out of it, it's unlikely that that's going to happen because the plea deal is given to you on the basis of what their policy is, and it's done before you even come into court that day. Unless you want to go through a formal deviation process or something like that, the plea deal has been pre-decided based on the prosecuting agency's policies. A lot of prosecutors will do this, but some will not. When you go in and you speak to them, they will typically give you three options. They'll say, I represent the government, I'm not your lawyer. You have a couple of options today. This is the plea deal. You can take the plea deal in front of you. If you don't want to do that, you can set your case to trial. So you're going to go to trial, represent yourself, which is a terrible idea. Or number three, you can ask for a continuance. They're not going to give you a number of different continuances, but those are typically the three options that they will give you. They're not going to just try to work this out with you or have a conversation with you in most situations because of the fact they have a policy. They're prosecutors. They're representing the government. They're not representing you. So be very careful if you are going to talk to the prosecutor without an attorney. If you have a lawyer, we are not going to let you talk to the prosecutor. Absent very, very rare circumstances, if we're agreeing to do a free talk or something like that, that may change. But by and large, you do not talk to the prosecutor. Your right to remain silent, your right to be outside of the process and be represented by counsel is a fundamental right. We exercise that. We are going to do the talking because of certain rules of admissibility and evidentiary rules if the case were to go to trial. So just keep this stuff in mind. If you're going to be talking to the prosecutor, be very careful about what you say and how you say it. If you want to speak to our team because you're not entitled to a public defender, you want to consider hiring an attorney, we'd be happy to speak with you. We offer free case evaluations. We'll sit down. We'll figure out what happened in your case. Make sure that you have a plan to move forward and make this all go away. Free case evaluations, literally nothing to lose. So give us a call. We look forward to speaking with you soon. Thanks for watching.